I'm Drew Stevenson, and this is a lecture for professional responsibility about Model Rule 7.6, political contributions to obtain legal engagements or appointments by judges. This is a very lightly tested subject on the MPRE, and this will be a short video because there's only one section of this rule. This is Rule 7.6. A lawyer or law firm shall not accept a government legal engagement or an appointment by a judge if the lawyer or law firm makes a political contribution or solicits political contributions for the purpose of obtaining or being considered for that type of legal engagement or appointment. So let's talk about this for just a moment. The actual prohibition or a kind of bright line rule that we have in this provision is against taking appointments, not making contributions. But the making of a contribution to a particular judge or local official can then set up a situation where you are prohibited from accepting certain types of legal work. And so this can apply to judges in areas where we have elected judges in states. We're not talking about indigent defense work and those types of court appointments. These are lucrative court appointments to handle estates and bankruptcy cases or to be a special master, and especially the municipal bond market. So we're not just talking about donations to judges, but also mayors and city council members and so forth, as you will see. So what is this really about? Well, we have a municipal bond market that's worth almost $4 trillion a year, and there's a long tradition of a pay-to-play system where lawyers give campaign contributions to state and local officials in hopes that they'll direct municipal and state bond business to their firms. Now, of course, state and federal laws already forbid bribery where you can prove it. And in the late 90s, the chair of the Securities and Exchange Commission asked the American Bar Association to ban pay-to-play. Now, this wasn't because the lawyers were doing incompetent legal work or inadequate legal work. It's just that the system is so fundamentally unfair. Firms would make large contributions to local government officials and then receive these gigs basically to do the legal work for a bond issue, and this can bring a lot of revenue into the firm. So let's look at just a few of the comments that define what counts as a contribution and what counts as a forbidden appointment. Okay, so first of all, a political contribution does not include uncompensated services. It does include almost everything else. So cash donations, obviously, letting a candidate use your facility for a reception or things like that. But it does not include volunteer work. So if you want to do phone banking or stand on a street corner holding a sign and passing out flyers for your favorite candidate for mayor, that won't count, which means if all you did was volunteer for a campaign, then you can still receive the type of appointment that you are hoping to receive. But we're talking about if it's something of value that's tangible or that you could set a dollar amount on, then it will count. Now, let's talk about what kinds of appointments are still okay. Uncompensated services. So if you are appointed as a special master by a judge, or you agree to do the legal work for a bond issue for free for the town, then nobody can fault you for that. We're not worried about you having a conflict of interest. Appointments made on the basis of experience, expertise, professional qualifications, and costs following a request for bids or proposals or other process that is free from the influence of campaign contributions, or appointments made on a rotational basis from a list compiled without regard to political contributions. And so please note, this means that you can still accept that very lucrative gig that you were kind of hoping for after making a contribution if your name just happened to come up on a rotational list, or if there's a request for bids or RFP, request for proposals, where every firm that wants to do this kind of work puts in a bid with cost and then saying that they're the most experienced and so forth. And so if you still receive the contract because you were the lowest bidder or you're the only firm in town that knows how to do municipal bond issues, the legal work for that, then that will still be okay. Okay, so we already talked about this, that it doesn't include, just to review, uncompensated services. So you do the legal work. Now, we talked about uncompensated volunteer work for the campaign, but then if you get a gig and you do it for pro bono, that's not prohibited. And then, as we said, things where you bid against other firms or there's just a rotation. Okay, we also have a motive test that in some ways is undermines the enforceability of this rule, to be honest. So how do we know that you made that contribution in order to obtain that particular type of legal work, and so therefore you're forbidden from accepting that appointment or legal engagement? Well, it's a but-for test. But for the desire to be considered for the legal engagement or appointment, the lawyer or law firm would not have made or solicited the contributions. And we can infer this from the circumstances in which the contributions occur. This is comment 5 to Rule 7.6. What do we mean by the circumstances? Well, did you donate to the candidates from both parties or to everybody who was running for a particular office, Republican, Democrat, everything? If you donated to everybody, including people that were running against each other, it really looks like you weren't donating just because you thought that this was a person who was best for the job, or you were donating according to your party preferences. On the other hand, it's permissible to accept an appointment or a legal engagement if the contribution was originally made to further political, social, or economic interests. In other words, you really believe this was the best candidate for the job, or because of an existing personal, family, or professional relationship with the candidate. So if you're related to the person, they worked with you at your firm, or you have a close friendship with them, something like that, of course you're going to donate to them and to their campaign when they're running for city council or mayor or something like that. And that would be a permissible motive, which means the legal engagements are not off limits for you. Okay, here's a review question to see if you've been paying attention. Is it permissible for a firm to make donations to the campaigns of all the local government candidates in hopes of obtaining lucrative legal engagements to handle municipal bond issues? Yes or no? Hopefully you know the answer to that, and if not, you weren't really paying attention and should rewatch this video. And that concludes our lecture about ABA Model Rule 7.6.